I've requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
In fact, to be very honest, I welcome this interruption.
Can I ask you a question? Can I ask?
Far right.
Please. What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers. No.
In fact, the powers will be whittled down. As if this law goes through, the powers will be whittled down, but we will explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is, of course, 2000. I will continue. Let me
note kar le, baad mein kar le.
Let me continue.
Mr. Khwaja, I will add.
Then is
Mr. Khwaja.
Yes, sir.
Right side.
Right side. Okay.
I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice has been. I think that's the moot question.
The answer to that is that it's noted, sir. It's noted, and I will only say this thing, that Supreme Court, what is Supreme Court? Supreme Court is the Chief Justice and so many other judges.
Faez will be sitting here till 12 o'clock.
I know that, sir.
So, आप जरा अपना argument करें. अभी तो हम section 3 पे पहुँचे.
Let me, on section 3, I will only say this thing, that this certainly is, the Parliament has taken away the power not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition, I've not even heard, and 3 judges or about 2 judges, they will decide on an administrative side and I'll be out. So the question of 184.3 will become totally redundant. This is my point. Therefore, to that extent, section 3 is present. Then next is 4. Interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court.
Do you object for say, I object to this provision, or you endorse it?
I will say this thing, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or why not 7, why not 6?
Please.
I object to this thing, that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just safe? Is this ultra vires the Constitution, section 4? Say something, we should note it.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges. Because this is very strange, because all judges are equal. Your Lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, not less than 5, then there's a question of appeal, and which is a very relevant point.
Sahab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have noted this thing.
Yes.
Your Lordship did not, sir, I would not be able to explain. It's my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the parliament. About how the benches are to be
आगे
formed.
बढ़ते हैं.
I will dwell on that.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir.
This is your
No,
suggestion.
sir, I'm saying this thing that under the 1980 rules, that power had been given. All of you sitting together feel that under 191 that this should be changed, then it is your functions. It is not the function of the parliament.
ठीक है, now let's proceed. We'll ask.
I'll argue on that.
लेकिन अगर आप-
That is the point which needs consideration. 5 is appeal. Yes, Mani, sir.
Sir, on section 4,
Also.
if memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches, the question is this: that model, that aspect was not accepted by the framers of the present Constitution because they had a model both from India and from Pakistan itself. So the question is this: if that was not accepted, does this not require constitutional amendments? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question, please note.
Yeah, it's noted, sir, and I may add on to this.
भैया
thing.
साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी।
मैं इधर हूँ जी।
जी, sir.
हाँ जी। भाई बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुन लीजिए सवाल तो सुन लें।
जी जी।
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है। ये आपकी बहस है ना सारी?
नहीं सर, ऐसे नहीं है।
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर, ऐसे नहीं।
सुप्रीम कोर्ट
नहीं सर, ऐसे नहीं है।
चलिए बस नोट कर लीजिए।
मैं नोट कर लिए कि जब सुप्रीम कोर्ट
अब जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब देता हूं।
ठीक है, अदरवाइज तो आपकी मुश्किल काम हो जाएगा।
मैं आई एम क्वाइट आई हैव वेरी
नहीं, आगे बढ़ते हैं।
I have worked with all of you, sir.
आगे बढ़िए।
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए।
कोई problem नहीं है. I understand what Shah Sahab is suggesting and saying, and he has mentioned this in many other cases. Yes, ma'am.
If I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked. Independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you. Surely, the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect the independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself? Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
Not through ordinary
नहीं
legislation.
आप नोट कर लें
कर लिए.
जवाब ना दें
Not through ordinary legislation.
Just for dollars.
If I will really request my colleagues that they are making, including myself, are making your life impossible.
I'm
No, please, no, you are very fine.
I'm
No.
learning.
No, we are not here to teach you anything. You are here to help us. Now, please, we're not even reading the act and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we are stuck with section. We are not even making progress. Please continue in your way.
आगे बढ़ते हैं. But let me say this thing.
Mr. Khwaja,
पहले ख्वाजा साहब सेक्शन 5 से आगे पढ़ लीजिए.
another question with regard to appeal. आप देखें हमारे पास already एक dictator का ordinance था, Law Reform Ordinance 1972. उसके तहत आर्टिकल 199 के लिए अपील प्रोवाइड की गई बिफोर 2 member benches. We are following it. क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? वहाँ तो अपील का राइट दिया, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199 हियर आर्टिकल 183 84(3). तो ये क्या दोनों में
Sir, it is
गलत है तो फिर वो भी गलत है.
it is not. We'll answer this thing that what Parliament can do and what Parliament can do many things. My Lord has said so. But there is a procedure provided. We'll answer that.
भाई साहब अभी जो आपकी जरूरत नहीं है आप प्लीज एक्ट
I will not answer it.
पहले एक्ट को खत्म कर
Section
लीजिए.
5 से आप आगे बढ़ लीजिए ख्वाजा साहब.
ख्वाजा साहब
You have collected 100 questions.
Just here. The law reforms ordinance of
Continue. How you will
1972.
answer.
This is the question to you. Regulated right of appeal
101.
within the High Court itself, an intra-court appeal. Was there ever a clause on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clog is there only in respect of the Supreme Court. Law reforms ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent list, which is now no longer there, and also the clog was only in relation to Supreme Court. Question: is therefore the law reforms ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clog.
Mr. Noted, sir. And appreciate. Section 5. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person of this act, provided that the appeal under this section shall be filed within 30 days of the commencement of this act. I'm not going to analyze it. I have my serious objection on this, and I will.
What you have to do, you're saying I'm not going to do it.
Well,
You have challenged a law, you have to do, you have to challenge it.
Appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
As far as section 5 is concerned,
Is it good, is it bad? First tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184(3), then why is this not they included in clause 2, whereby my 184(3) application will be disposed
Is
of?
that the way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes I am, no I am not. These are my reasons.
my lord, I have a reservation on this.
You may have
that
reservations,
I-
tell us unconstitutional about it.
But then let me explain it to them, because if I start explaining it at this stage, it will take your time. But I will say this thing, that this section 5 should have also, this right of appeal should also have been given in section 2.
Should is different
Or
from
it ought to
ultra
have been
vires the
given, or it ought to
constitution.
have been given.
What, then you go and move a bill in parliament. We are saying, are you opposed to section 5? Give us legal reasonings, or you say it's okay. अब उनसे आप पूछेंगे
You have done this.
नहीं ये नहीं आप जवाब दीजिए ना आपने पिटिशन लाए दिस इज
इसमें-
नॉट फेयर
To make it more simple, you don't want your client to have a right of appeal.
No, sir, I
first say it's unconstitutional it's constitutional you're not saying anything you just यहाँ कोई discussion होता है sorry not on this is your job in office
My lord, may I say this thing that we divided the.
please answer the question is this constitutional or unconstitutional I can't hear
इसकी
you
वायरिस तो बताइए ना, वायरिस क्या है?
है unconstitutional आपके जहन में और नहीं है
Unconstitutional.
Well, it's my personal opinion is this, that this section 5 goes beyond the powers which were there with the parliament.
The
So,
ultra
now
vires
formulate a contention on that please formulate a contention
for the simple reason, my lord, if an appeal is to be provided, it's a substantive right, there has to be a constitutional amendment to provide an appeal under section 184(3).
ठीक है
Because
okay
that, and this appeal to this act, an ordinary law cannot provide.
I
it.
can't seem to reconcile your, which I appear to me to be contradictory submissions.
No, I'm simply saying
Please
that-
let me finish.
that this-
Please let me finish.
Yes, ma'am.
On the one hand, you are saying, where will I go? Where will I go? Here the parliament has given you a right. You say it's unconstitutional. So please don't make contradictory contentions.
I'm only saying this thing, that it's a good thing that the appeal be given, but the manner in which it has to be given
Man,
is
take it,
wrong.
please take it.
And I'm saying this thing, that this one, the right of appeal given in this manner by an ordinary law.
We will not
is
strike it down because of manner. You have to show us ultra vires the
It is
constitution.
unconstitutional, sir.
But saying so, no argument.
Our argument is this, that 184(3) is a substantive provision of the Constitution. If a
You
right
are
of
happy
appeal-
with no appeal.
Well, Lord, if a right of appeal has to be given, there has to be a constitutional amendment.
ठीक है, okay, point taken, move ahead.
ठीक है, ठीक है। ये बात नहीं पाई।
I just have a question to you with regard to section 5 from what you have just said. Kindly read it again.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution.
Just kindly stop. So this order, the question to you is, has two parts. So the first part is, this question, this order, which is now made appealable, is it a judicial order or is it administrative type of order? And if it is a judicial order, then how can Parliament, in exercise of a legislative competence,